In this screencast, we'll discuss one of the most famous and maybe not well understood cases in law enforcement, Miranda versus Arizona. This case starts in the 1960s in Phoenix. A young woman was walking to a bus when she was shoved into a car. Her hands and ankles were tied, and she was driven to an unknown location and raped. The male suspect in the case released her near her home. Ernesto Miranda was later arrested for this offense. He was taken to a police station where he was questioned. At the time, he was 23 years old, he was poor, he had a 9th grade education, and was possibly mentally ill with pronounced sexual fantasies. He already had a lengthy police record, and he was interrogated for about 2 hours at the station, during which he made a written confession. Now at the time, there's a technical requirement for peace officers to advise a suspect of their right to have counsel, but it's not universally adhered to. In fact, officers admitted not doing this during the trial. Officers also lied to Miranda during the interrogation. They said the victim had already identified him as the attacker, although she did later identify him. Miranda's confession was used against him, and he was convicted at the trial court of rape and kidnapping. His case and conviction was appealed. Miranda's lawyer claimed that Miranda had not been told of his right to remain silent or to an attorney, which made the confession illegal. Well, the state of Arizona argued, well, he could have asked for a lawyer at any time, and he was aware of his rights and confessed voluntarily. The case went all the way to the Supreme Court. The Supreme Court said that the Fifth Amendment privilege is so fundamental to our system of constitutional rule that a defendant's knowledge of it should be asserted. Speculation is not enough. The warning that a peace officer might give would be a clear-cut fact. Now, this is a very controversial ruling at the time, and the court itself was divided by a 5-4 vote. Miranda's conviction was reversed and remanded and sent back to the trial court. He was retried, this time without the confession, and reconvicted. Now, some years later, after he gotten out of prison, serving his sentence, Ernesto Miranda was murdered during a card game by another man. When that man was arrested, he was read his Miranda rights. The Supreme Court handed down some very strict guidelines in Miranda versus Arizona. They said warnings must be given to the suspect, including the right to remain silent. Any statement a suspect makes may be used as evidence against them. A suspect is entitled to consult a lawyer. And if he or she cannot afford a lawyer, the state will make one available to him or her before they are questioned. Please note, by the Code of Criminal Procedure, a Texas peace officer must also advise of the right to terminate the questioning at any time. Now, there's a lot of misunderstanding, especially by people who watch a lot of TV and then later on get arrested. Miranda warnings don't have to be advised to a person who is simply under arrest. They are only required when 2 conditions are met. First of all, a suspect has to be in custody, which means not free to leave. Secondly, they have to be asked questions of an incriminating nature. This is referred to essentially as an interrogation. If a suspect is free to leave, or they're being asked non-incriminating questions, or if they're under arrest and not being asked any questions at all, no Miranda warning is required. The right to counsel may be waived if the waiver is made voluntarily and with the knowledge of the consequences. In this case, the burden of proof is on the state. And also keep in mind, a suspect may withdraw their waiver at any time. In other words, if a suspect initially acknowledges their rights and agrees to answer questions from a peace officer, they can choose to stop answering questions at any time. Once a suspect says, "I want a lawyer," questioning must stop and can continue only after counsel has been obtained and is present.